right, well, welcome back. Long time no see. Sorry for how all of this worked out. In that I was away for the strongman contest, and then we had the exam, so I didn't see any of you for an additional 2 weeks before school was canceled. So I apologize for the lengthy time that we haven't seen each other. But nonetheless, I hope this video finds you all doing well, even if you're stuck at home and hopefully not too bored by this point. So for this week, you're going to have two discussion boards that are due. So there's one on bullying in the NFL. It's a case many of you are probably familiar with, although it's a little bit older at this point. And then there is a separate discussion board that is on basically a really toxic work environment at a company that makes or made mascots. So make sure by Sunday night at 11:59 that you're sure to complete both of those discussion board assignments. And this will be the only week that we have two of them. I just had to double up because we unexpectedly had to skip that last week before spring break. So that's why you have two this week. Both of them are 300 words. So make sure you hit the word limit. And then the other thing is to make sure that you do those after you watch the video and try to apply as much of the stuff as much of the material as possible from this chapter to your response on the discussion board. And then one final aside is that if you hear some cheering here and there, that is my son in the basement playing NHL on the Xbox, so I apologize for that. All right, so moving on with employment law. So first things first here is the employment relationship itself. So one of the things to keep in mind, this crosses over some with agency law. So remember that if you are an employee of the company, many times you are an agent of the company in that you are doing things, taking actions to try to further the company's interest, whether that is making sales, whether that is going out and setting up advertising, any number of other things like that. So as an agent of the company, you have certain powers. So obviously you can bind that company to legally binding contracts. So that may be that you agree to purchase a certain amount or a certain type of equipment. But then as we discussed with the agency law chapter, that also means that the company is or can be liable for your actions if they occur within your scope, the things that you're allowed to do. And so because of that, being able to define the employment relationship becomes really important. So as we saw, one of the key questions on the BGS case study was, what was the scope of employment? Was the party, pretty sure that was Jake, should have looked before I recorded this, but nonetheless, was the guy who was out driving around selling gloves, was he authorized to do that? And obviously that was a pretty key question that defined whether or not BGS was liable in that case. So being able to define the scope of employment is really important from a liability standpoint. So employment at will, the concept there is that the employer or the employee can terminate that relationship at any time for any reason. So what that means is that your employer can decide to fire you for any reason as long as it's not discriminatory. So you see the little thing down there, the fifth bullet point down there, must avoid statutory violations. What that means is the reason that they fire you can't be something illegal. So for example, retaliation. So let's say you're in an unsafe work environment, they're not giving you the protective gear that you need, and so you report the company to OSHA, which is the Occupational Safety and Health Administration. So if they fired you for reporting their violations to OSHA, then that would be retaliation and that would be illegal. So that's not something they can actually fire you for. So in terms of avoiding statutory violations, you can't discharge anybody for reporting illegal conduct. You can't discriminate against somebody, so it can't be a discriminatory reason because you've decided you have too many women in the workforce or too many minorities, whatever. You can't do that, obviously. And then retaliation is another big one that companies might do. That would be a statutory violation. So, but outside of those things, outside of those statutory violations, the employer is able to get rid of the employee at any time or for any reason, and they can also alter their employment conditions. So they may switch you from first shift to second shift or something like that. And so if you don't like that, then the other side of employment at will is that you're able to leave at any time and for any reason. And the bullet there where it says as opposed to for cause, If you get fired for cause, it is because you did something wrong. So maybe you just have terrible job performance ratings. So as an instructor, maybe all of the students gave me a 1 out of 5 on everything, and I barely showed up to class or any of those kind of things. I basically didn't do my job. If I get fired for that, well, that's getting fired for cause. So that's obviously different than some of the other possible reasons that you could lose your job. So I have a video there in the lower right, and it's obviously a very dated reference at this point, but I'll make it nonetheless. So it comes from a video called Office Space, or a movie named Office Space that came out when I was in high school, but it was one that I really enjoyed. And so the reason I put it on there is because it's this, he's basically describing employment at will. So I'll play the video for you, or most of the video for you now.
So, where do you work, Peter?
Initech.
And what do you do there?
I sit in a cubicle, and I update bank software for the 2000 switch.
What's that?
Well, see, they wrote all this bank software, and to save space, they used 2 digits for the date instead of 4, so like 98 instead of 1998. So I go through these thousands of lines of code, and it doesn't really matter. I don't like my job, and I don't think I'm gonna go anymore.
You're just not gonna go?
Yeah,
Won't you get fired?
I don't know. But I really don't like it, and I'm not gonna go.
So you're gonna quit?
Nah, not really. I'm just gonna stop going.
When did you decide all?
So what he's describing there, coming back, what he's describing there is that employment at will. That he's not going to quit. He's just not going to go anymore. So that's the employee end of it, is that you have the ability to leave at any time. Now, depending upon what kind of job we're talking about, you may have an employment contract. So if you're teaching, you're more than likely going to have a contract. I know I had one when I worked as a high school teacher and coach. And so in those contracts, obviously they're going to spell out your rights and obligations, so what it is that the employer is giving you, and then what it is that you have to do in return. So that might include, it would probably be more general than this, but the gist of it would be that you have to teach a certain amount of hours. So for example, in college level teaching contracts, it'll stipulate the amount of hours that you have to teach sometimes, so 12 credit hours per semester or 24 hours per year, something to that effect. And then, so those are your obligations, or those are my obligations, and then the rights would be things like whether or not there's insurance, your salary, in terms of insurance, the different types of benefits that you might receive. And then also there's typically a termination provision in there. So that includes, if you're the employee and you're leaving, how much notice you have to give. And that varies, or can vary, pretty dramatically. So sometimes in contracts, it can be 90 days, 60 days, 30 days, something to that effect. Pretty standard is 2 weeks to a month, but again, it depends upon the type of job. And even in an employment at will situation, if you want to use some of your employers as references in the future, it is professional courtesy to give them at least 2 to 4 weeks of notice, so they have the chance to replace you and hopefully bring in your replacement, have you work with them and train them up if you're leaving on friendly terms. And then the other thing is, if they're going to terminate you in a contract, it'll tell you how much notice they have to give you. So I've mentioned previously that the university that I came from, Concordia University in Texas, one of the things that they did was, so I mentioned that they had a really broad four cause clause. So how they could get rid of me. So things like disagreeing with church doctrine, and a number of other things in terms of financial exigency and different things like that. But it also included the fact that they had to give me a full 1 year notice if they wanted to not renew the contract. And that was not the case with some of my colleagues. So that's a really important information to know, is how much notice can you expect if they're looking at getting rid of you. So another important concept here is that if an employer is going to try to sever that relationship, one of the things that they may decide to do is to try to find a way to make your firing for cause. So for example, there's a lawsuit right now, which is former Kansas University football coach. His name is David Beatty. He was fired at the end or near the end of the 28 season after going 6-42 in 4 years. But because of them firing him for basically a poor record, in professional coaching, that's not a for-cause type of a termination. They don't usually put in their contracts that they can be fired for not performing well, as far as win-loss records go. And so because that wasn't a for-cause termination, Kansas was going to owe Beatty $3 million in liquidated damages. So what they did was they, in Beatty's words, tried to find dirt on him. And so they basically went out and tried to find things that he might have done wrong. And then they self-reported some NCAA violations. And so specifically what Kansas self-reported was that one of the video coordinators coached the quarterbacks on 2 or 3 separate occasions, which is a violation of NCAA rules because only the on-field coaches, and I think they're permitted 10 at that level, only those 10 on-field coaches are allowed to interact with the players. And so because this video coordinator interacted with a player, that's more than those 10 that are authorized to do so. And so technically that's an NCAA violation. And so basically what Kansas did was they went out and tried to find something that was a violation so that they could argue that he's getting fired for cause, because while having a losing record is not an appropriate cause or an acceptable cause to fire a coach, violating NCAA rules is. And so they were trying to find a way, and again, Kansas self-reported the NCAA violation so that it would give them some leverage to say, look, we fired him because he violated NCAA rules, and because he was fired for cause, we don't owe him that $3 million. So when employers are trying to get rid of you, that is one of the things that they will pretty commonly do, is try to find a reason that you did something wrong, whether you misused your email or were insubordinate or you didn't have good enough performance evaluations, those kinds of things. They're always going to try to find something. So it'll be interesting to see how that case ends up turning out. All right. So in hiring and firing, if you make it to the level of a sport manager, which I hope that you all do if that's your goal, hiring and firing is fun. Well, not firing. Hiring is fun, generally. It takes a long time, but it is kind of fun. It is kind of rewarding, especially if you pick somebody who works out well and they fit well within the organization and they're successful. That's a fun aspect of the job. But of course, if you hire somebody, well then, or if you have the authority to hire, then you also have the responsibility to fire people or to engage in layoffs. And of course, that can be a really difficult part of that process. And so in either of those things, in hiring or firing, one of the things that you have to avoid is discrimination, is unduly separating or setting aside parties in any of these protected classes. So you can see the 3 different categories of protected classes. The first there, race, color, or national origin. The second is gender, and then the last one is religion. So you can see that those categories come from Title VII of the Civil Rights Act of 1964. And an important thing to understand is who that applies to. So that applies to governmental agencies, federal government employees, labor unions, and employers with 15 or more employees. So if you have a small business that only has 2 or 3 people, well then the Civil Rights Act of 1964, at least some of that discriminatory aspect doesn't necessarily apply to you, because that might be unduly burdensome in such a small company. So applies to companies with 15 or more employees. The thing you can see on there, the Equal Employment Opportunity Commission, or EEOC, as you can see from the slide, that's the agency that monitors compliance with Title VII. So if somebody believes they've been discriminated against, the first thing that they will do would be to file a complaint with the Equal Employment Opportunity Commission, who will then investigate. And obviously you can also file a civil suit as well, but the most common way to go with that is to go to the EEOC first. So in terms of discrimination, essentially there's kind of 2 ways to think about it. Either it can be intentional or unintentional. But before I get to that, I do have this little video in the lower right, because I was talking about hiring and firing, and so it reminded me of again, another dated reference with Homer Simpson and him cutting players when he's a football coach.
Okay, it's time for the easiest part of any coach's job, the cuts. Now, while I wasn't able to cut everyone I wanted to, I have cut a lot of you. Wendell is cut. Rudy is cut. Janie, you're gone. Steven, I like your hustle. That's why it was so hard to cut you. Congratulations. The rest of you made the team. Except you, and you.
So, if nothing else, hopefully, if you get tasked with firing or layoffs, you're a little bit more empathetic than Homer when he's cutting his players. All right, so back to intentional versus unintentional discrimination. So disparate impact discrimination is, as you can see there, unintentional. And so what it is typically is that there's some kind of a rule that the company makes that causes the workforce at that company to not mirror the labor market. So you might have some kind of a rule that limits the ability of people over the age of 50 to work at your company. And if you're in Florida, well, then that may be a large proportion of the labor force. So for example, let's say I'm running a gym and I have a rule that says in order to be a personal trainer at this gym, you have to be able to bench press 300 pounds. Well, that rule, the intent of the rule is not necessarily discriminatory, but the effect of the rule might be in that if the rule is you have to bench press 300 pounds to work as a personal trainer, well, then that's probably going to keep a lot of women from working there as personal trainers, and that will probably also keep anybody over the age of about 50 from working there as a personal trainer, and that's a pretty generous estimate. But so then the effect of the rule is going to be to eliminate a lot of women from your workforce and also to eliminate a lot of middle-aged and older people from your workforce. So that disparate impact discrimination then is that there's, again, some kind of a rule that has the effect of discriminating. In the original case where this was outlined comes from North Carolina in 1971, and the case is Griggs versus Duke Power. And so this power company, the rule that they put in place was in order to get to certain higher paying positions in the company, the requirement was that you had a high school diploma and pass an aptitude test in order to be eligible for those jobs. Now, as it happened at the time in the early 1970s in North Carolina, only 12% of African American males had a high school diploma at the time. So effectively only 12% of that group would be eligible for those jobs, as opposed to 34% of white males in North Carolina at the same time had a high school diploma. So because of that, that rule disproportionately impacted African American applicants. And then the other part of it is that only 6% of African Americans passed the test, while 58% of white applicants passed the test. So don't know what was in the test, but there may be some questions that might have some cultural assumptions in there, and so that may have played a role in the significantly lower pass rate for African American applicants. But effectively what happened there was that Duke Power wasn't able to show that passing the test was necessary in order for someone to be able to perform the job. So that's as opposed to like a licensure exam, for example. If you want to be a nurse or a physician or a physical therapist, there are licensure exams in order to obtain the credential to work in any of those kinds of professions. And so they would be able to, whatever hospital hired you, would be able to reasonably show that there's a relationship between being able to pass that test and understand that material and being able to perform that job. Well, since Duke wasn't able to show that relationship, that it was necessary to have a high school diploma and pass that aptitude test in order to successfully perform the job, effectively the rule that they put in place was arbitrary, and so the court ruled that that was something that was not allowed, and so had the effect of discriminating, and so the company had to do away with that rule. Now that said, as we'll discuss more here in a minute, there can be a defense for that, which is this concept of bona fide occupational qualification, which we'll get to on this next slide. So disparate impact discrimination, again, the important thing to know there is that it is unintentional discrimination, as opposed to disparate treatment discrimination is where there is intentional discrimination. So in order to prove that, the person who's been discriminated against has to prove the things that you can see on there. So they have to prove that they're a member of the protected class, so they are a racial minority, they are a woman. One of the other things that they might be able to show is that they were discriminated against based on their age, and we'll talk more about that in a later slide, or that they were discriminated against based upon their religion. Then, once they've proven that they were part of that class, then they have to show that they were qualified for the job. So it's not that they didn't get the job, or that they were passed over for the promotion, or that they got fired because of because they weren't qualified, they weren't able to perform the job. But in fact, the reason that they didn't get the job, got passed over for the promotion, or they got fired is because of their membership in that protected class, that they were discriminated against on the basis of race, gender, religion, or age. So one of the terms I'm going to start using now is an adverse employment action. So an adverse employment action typically means that someone gets fired or laid off, but it can also mean that they got passed over for a promotion, or you can also view it as being not hired. So then the last thing, once they've proven that they're a member of the protected class, that they're qualified for the job, then they have to show that the job either remained open or was offered to someone who is not in that protected class. So that might be that they, got passed over for an applicant who basically has the same qualifications, potentially lesser qualifications, but despite that, they didn't belong to that class. They were, let's say, a white male potentially, and were hired for the job instead. So that would be a case of intentional discrimination. So the last thing on there is bona fide occupational qualification, or BFOQ. So there are times where you can have a rule, or you can openly discriminate if you can show that the reason for the discrimination is necessary for the job. Now that said, race can never be a bona fide occupational qualification, but gender might be. So there's a new gym that opened up in Brookfield back in November. And so that gym is Lifetime Fitness. It's a monster Globo gym. Highly recommend it if you have the opportunity to work out there. It's pretty cool. But in that gym, they have these huge locker rooms with lots of rows of lockers, and a lot of them, not the one in Brookfield, but some of the other locations of Lifetime have like TV lounges in there and all kinds of stuff going on in these really big locker rooms. And so in both locker rooms, there are locker room attendants. And so if I were to post a job to work as a locker room attendant in the women's locker room there at Lifetime, one of the things that I would probably stipulate in that job is that applicants, or the person who was hired for the job, had to be a woman. And so if a man applied for that job and I didn't hire him on the basis of his sex in that case, and he turned around and sued me and said that I was discriminating against him, what I would say is that it's a bona fide occupational qualification that whoever holds that job be a woman, because the patrons of my gym, all the women who are in that locker room, are not necessarily going to feel safe in that locker room. And so if there are male attendants in there, they may not feel safe. And so because of that, that could hurt my business. And so that is the reason that I'm discriminating there. And that one would almost certainly be allowed to fly. Similarly, the thing I mentioned earlier about being able to bench press 300 pounds in order to be a personal trainer, if you can show that that is necessary in order to perform that job, then that could be a bona fide occupational qualification. But the reason you would have some sort of strength requirement, so an actual example is tests for firefighters. So they have to be able to perform a certain physical test in order to be a firefighter. So you have to do different things like carrying a dummy. I think there's an up and down stairs thing. Should have looked up the requirements, but dragging a hose. There's a number of different things they have to be able to do. And so the argument for those fire departments, if somebody said they discriminated against them on their physical ability, is no, these are the things you need to do in order to perform this job. And if you can't do these tasks, then you won't be able to save lives or do the things that need to be done in order to perform well as a firefighter and to protect the public. So those could be your bona fide occupational qualifications. An important thing to understand here too is, so remember that one of those protected classes is religion. And so certain religions have days that they are not allowed to work. So one of the things, if you're running a smaller company, again, more than 15 employees, but if you're running a smaller company and you have a potential employee who comes in and says, well, based on my religious beliefs, I can't work on Saturdays, and you really need somebody who's available on Saturdays in addition to some other days, and you pass them up, if that's the deciding factor, they can't work Saturdays because of their religion, and you pass them up for that, then that is intentional discrimination. So the key there is that your decision to hire or not hire them cannot be solely based on potential time conflicts that would stem from the applicant's sincerely held religious beliefs. And so sincerely held is some important wording there as well. So the last thing I would say about that is the only exception would be if that sort of accommodation if you could prove that it created an undue hardship for the function of the business. So again, if you're a really small organization, so you only have 15 employees, and if that one person can never work Saturdays, and basically you're only open Saturdays and Sundays or something to that effect, if you can show that that's an undue hardship for your business, well, then their discrimination case would have no merit. So you can see here the things that one would need to prove if there was a complaint about racial discrimination. So the things that they're going to have to prove, pretty similar to what we talked about in the last slide. So membership in a protected class, if they're already employed, that they had satisfactory job performance, that there was some sort of an adverse employment action, so either they got fired or they got passed over for a promotion, something to that effect, and that the way that that adverse employment action occurred gives rise to the idea that there was discrimination that took place. So on the bottom there, so disparate treatment. So the individual is going to have to prove that the defendant, whoever it is that discriminated against them, the employer in that case, was motivated by discriminatory animus through direct or circumstantial evidence. So direct evidence is they know that they were passed over based on their race, or there's an email to that effect. Somebody heard the employer say, yeah, I would have hired them but for their race. Obviously, nobody's going to phrase it quite like that, but something to that effect, that there's evidence that the deciding factor was race in firing them or passing them over for promotion, something to that effect. Indirect or circumstantial evidence. So one of the more common examples that people point to in sports is the low number of minority head coaches, particularly African American head coaches in major college sports and to some extent in major professional sports. So my numbers are a little bit old here. They come from 2016. But in 2016, 112 out of 128 Division I football coaches were white. So 87.5% of the coaches were white, while 59% of the players were non-white, and 47% of those were African American. In men's basketball, 77 out of 351, so 22% of coaches were African American, while nearly 73% of players were. And so the argument there is that there must be some discrimination that is taking place because you've got this really large pool of former college basketball players, former college football players who are African American, but they are drastically underrepresented in the coaching ranks. And so the argument there is that that's a form of indirect discrimination. Usually, if that comes up for a school, what they say is, well, there aren't very many qualified applicants. And so from a discrimination standpoint, the argument from that standpoint is, well, the individuals who are former players just haven't been given the opportunity, and so that's why there aren't any qualified applicants. So beyond whether or not they make head coach, some have alleged that in order to be promoted, that black coaches have to be better performing than their white counterparts in order to get a shot. So for example, this was borne out by a research paper from the Georgetown University School of Business in 2016, and that paper looked at 1,200 NFL coaches from 1985 to 2012, and they found that white assistant coaches were more than twice as likely to be promoted than similarly performing minority candidates. And the authors also said that it takes 9 years before a white assistant has a greater than 50% chance of becoming an offensive or defensive coordinator, as opposed to 14 years for African American coaches. In a similar but more dated paper by an author named Janice Madden from the University of Pennsylvania in 2004, she looked at NFL head coaches between 1990 and 2002. And most specifically, she compared African American head coaches in the NFL during that span to white head coaches during that span. She looked at season records, whether or not they made the playoffs, their first season record, and their final season record, and whether or not the coaches left voluntarily. So during that span, again between 1990 and 2002, African American coaches averaged 9.1 wins per year compared to 8.0 wins for white coaches. African American coaches did have a losing record in the playoffs, as none reached the Super Bowl during that span, but it's important to note that there were only 2 African American head coaches in the NFL during that time. When fired, the African American head coaches averaged 6.8 wins as opposed to 5.6 wins for white coaches. So the argument there, or the observation there, is that African American coaches had higher win totals than their white counterparts, and that when they were fired, they had closer to a 500 record than their white counterparts did. And so according to Janice Madden, the author of the article, that demonstrates the notion that black coaches have to be better than their white counterparts in order to keep their jobs. She did a follow-up study in 2011 and looked at data between 2003 and 2009 and showed that after the Rooney Rule, which we'll talk about on the next slide, the number of African American coaches went from 2 to 6 or 7, depending on the year, and the performance advantage of African American coaches decreased. So they didn't necessarily have more than one win per season on their white counterparts, and they didn't necessarily have that big gap whenever they were fired. Still, though, lower level positions didn't follow the same trend because there's no requirement among NFL clubs to interview minority candidates for coaches beyond the head coach position, and African American coaches still had higher performances in limited numbers. So the idea with all of that stuff is that that's indirect or circumstantial evidence of discrimination that's occurring in terms of hiring coaches or promoting coaches. So that then is related to our next slide, if it'll come up. There we go. Affirmative action. So you can see that the overarching idea of affirmative action is that there was a history of racial discrimination that kept qualified African American and other candidates, so other minorities, and also there's gender discrimination involved here too. But the idea behind affirmative action is that there were a number of structural things in place that kept minorities from being able to achieve the highest positions within an organization, or kept women from achieving the highest positions within an organization. Typically, especially as it pertains to women, that is referred to as the glass ceiling. So affirmative action, the idea is to proactively, to intentionally seek to undo that. So if you've got two candidates who are roughly equally qualified, then you would give preference to the minority candidate, or at the very least, it's probably not the best way to put that, but at the very least that race can be one of the things that is considered. And so again, the idea is that you are playing a role in undoing or offsetting previous discrimination. So oftentimes when you look for jobs, you'll find that the organizations you might be looking at have affirmative action statements. So for example, they might say something to the effect that they, quote, actively seek and encourage, end quote, applications from individuals who are members of underrepresented groups. So again, that could be African Americans, but that could also be women or other religious or ethnic minorities. So from a sports standpoint, one of the most common places, or one of the most prominent ways that you might have heard about affirmative action is the NFL's Rooney Rule. And so the Rooney Rule is named for the former owner of the Pittsburgh Steelers. I think he actually passed. I think it's named for Art Rooney. But nonetheless, the owner of the Pittsburgh Steelers, that's who the Rooney Rule is named for. And what the rule says is that clubs are required to interview minority candidates for head coaching and senior football operations positions, but not for lower level assistants. There's no obligation to interview minority candidates for those positions. So usually when people talk about the success of affirmative action from a sports standpoint, one of the things that they'll do is point to the Rooney Rule, and they'll point to, in particular, Mike Tomlin, who's pictured there in the lower right. And so Mike Tomlin is the current coach of the Pittsburgh Steelers. He was interviewed under the Rooney Rule requirement with the Steelers owner at the time, Dan Rooney, saying that, quote, before the interview, he being Tomlin, was just another guy who was an assistant coach. At the time, Tomlin was a defensive coordinator with the Vikings. Once we interviewed him the first time, he just came through and we thought it was great. We brought him back and he ended up winning the job, end quote. So Rooney, the Rule's namesake, had nothing but positive things to say about Tomlin. They hired him in 2007. It's worked out really well for the Pittsburgh Steelers since that time. So as of the end of the 2019 season, Tomlin's record is 141 wins, 81 losses, and 1 tie. And so as an NFL, or as a head coach, he has a winning percentage of .635, which is number 2 in terms of winning percentage among active NFL coaches, and he is second only to Bill Belichick, whose winning percentage is 686. So Belichick winning almost 70% of his games, and then Tomlin in second at just under 64% of his games. And an important thing about that, too, is that Tomlin has fared much better than the legendary Steelers coach Chuck Noll, who put up a 566 winning percentage. So when the Rooney Rule was instituted in 2003, at that time there were only 2 black head coaches in the NFL, and as of 2018, there were 8 minority head coaches in the NFL. So the rule has had a pretty profound effect on the NFL, going from just a couple coaches to a quarter of the league by 2018. So it still took 15 years, but it has made a substantial impact on the highest levels of the NFL. Next slide. There we go. All right, disability discrimination. So as far as disabilities go, the last several decades have seen an increase in the number of disabled athletes competing, which is obviously good. But whether that increase has led to an increase in the number of disabled PE teachers, coaches, officials, or athletic department personnel isn't known due to confidentiality concerns. So basically based on HIPAA, the Health Information Portability and Accessibility Act. It's what protects your medical records. That said, it's still unusual to have a disabled PE teacher or coach unless that individual became disabled after being unemployed or after being employed. So most of us are pretty familiar with the Americans with Disabilities Act, at least as a concept, but there are a couple other relevant acts to be aware of because those might have an impact on you or your career as a sport or recreation manager. So the first is the Rehabilitation Act of 1973, and what it does is prohibits discrimination based on disability, and it's applicable to educational programs and activities if they are recipients of federal funds. And so that's a really important thing, is that you have to show that that program is the recipient of a federal fund in order for it to, in order for that individual to be protected by the Rehabilitation Act. So what it says is, quote, "No otherwise qualified individuals with a disability in the United States shall, solely by reason of his or her disability, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program receiving federal financial assistance," end quote. So a plaintiff who sued or filed a suit under the Rehabilitation Act would have to prove that the activity or program received federal funding. So relevant for us is the fact that most Wisconsin schools get federal funding of some sort, and federal money accounts for 8 to 10% of school funding in Wisconsin. So where those sources of federal funding might come from include Title I, which are grants given to schools with high poverty, or IDEA funds, and we'll get to IDEA in a second, but IDEA funds are used to help support special ed programs. So as it pertains to public schools in Wisconsin, most public schools get some federal money, and so because of that would be subject to the provisions of the Rehabilitation Act preventing discrimination based on ability. So in terms of the other things the plaintiff has to prove, they have to prove they're disabled under the terms defined in the statute, which includes physical and mental impairments that interfere with a major life activity, including working. They also have to prove that the defendant discriminated against the plaintiff in an employment decision based on the individual's disability, and the plaintiff has to show that the employer knew of the disability before deciding not to hire or to terminate or to pass over for promotion, etc. And then the plaintiff also has to show that they're otherwise qualified. And so with, quote, reasonable accommodations, end quote, the person can perform the essential functions of the job in question. So the plaintiff then has to show program receives federal funding, that they're disabled, they were discriminated against based on the disability, and so this is going to be something we're going to return to repeatedly, is the idea as disability, age, race, gender, that has to be the determining factor. So in this case, the plaintiff would have to show that the determining factor in the decision to not hire them or not promote them or whatever the adverse employment decision was based on the disability and that they were otherwise qualified. And an important side note is that compensatory damages are allowed, so you can be compensated for if you didn't get the raise, you can be awarded the raise. If you were terminated early, you may be reinstated and then given back pay, that kind of thing. But punitive damages are not, so you couldn't sue for the money you missed out on, plus some exorbitant sum of punitive damages. So in terms of an actual case that fell under the Rehabilitation Act of 1973, that's why the lifeguard is on there. So the case is Schultz versus YMCA from 1998. So Schultz obviously is the plaintiff. And so a little bit about him. He was an experienced swimmer and instructor with approximately 15 years of experience as a Red Cross certified lifeguard. He was also deaf unless he's wearing his hearing aids. He was hired as an aquatics director for a Massachusetts YMCA in 1993. After employment, Schultz, the plaintiff, pursued lifeguard certification through the National YMCA organization, which was not required because remember, he has a Red Cross certification. He passed the YMCA certification with the exception of the hearing requirement. The National YMCA lifeguard certification requires that an individual, a lifeguard, be able to hear noises and distress signals. And Schultz was able to produce audiology reports showing he could hear with his hearing aids, and because of that report, he was able to get his YMCA certification. The person who administered the test also worked at the same YMCA that Schultz worked at, and noticed that Schultz often didn't wear his hearing aids while working, and he would turn his back to the pool while doing cleaning and administrative tasks. So because of that, she became very concerned because she had signed off on his YMCA lifeguard certification based on the idea that he could perform all of the physical tasks, but certainly also that he could hear, and he could when he wore his hearing aids, but of course she noted that he didn't wear them very often, and so she asked that the National YMCA take her name off of the certification, which they did, effectively revoking Schultz's certificate. So just prior to that, Schultz had already resigned as aquatics director and taken a lower paid position at the same YMCA due to poor performance ratings, so think here for cause, so due to poor performance ratings as the director. So he later resigned from his job. After he lost the YMCA certification, he sued the YMCA under the Rehabilitation Act. He sued both the national and local YMCA for $20 million and several claims, including emotional distress. He claimed to have sought therapy for depression and anxiety after the loss of that certification. So remember that judgments for emotional distress have typically only come with really egregious behavior. So we talked about the doctor who lied to the press that the football player had blood cancer. So there's something just really out of bounds, something really egregious. And so having one's name taken off of a certification doesn't really seem to fit that description. So Schultz ultimately loses the case, and the reason that he loses the case is that he couldn't show any direct economic loss because, again, he didn't actually have to possess that certification. If he just kept his Red Cross certification and performed the job well of aquatics director, then it wouldn't have mattered. The fact that he lost his YMCA certification didn't really have any bearing on his job. So further, the YMCA didn't act with malice toward him or the disabled, and the requirement for the certification, as mentioned, wasn't related to the safety of swimmers. So because the YMCA, because their decision wasn't based solely on his disability, and in fact he had taken a lower position because he didn't perform the job of aquatics director well, ultimately he was unsuccessful in that suit. So the court found further that there was no misbehavior or intentional infliction of injury on the part of the YMCA. So that's Schultz. All right, so I was going to say a side note there that was kind of interesting is that, so part of the requirement is that you have to be able to hear in order to get that YMCA certification, but Schultz was able to pull several experts who showed that drowning victims rarely make a noise, so the fact that certification requires a hearing, the ability to hear, doesn't entirely make sense, is at least what Schultz's expert witnesses were claiming. But again, ultimately, the YMCA certification didn't matter because he came in with a certification through the Red Cross that would have enabled him to have the job. And then the last one on there, second to last one, is the Individuals with Disabilities in Education Act, or the IDEA Act, which was passed in 1990. And the idea of the IDEA Act is that it's aimed at supporting special education to allow disabled students the right to receive a free, appropriate, and public education. And so the education should be designed to meet their needs in order to prepare them for employment and independent living. It was amended in 1997 to refer also to extracurricular activities and opportunities to compete in interscholastic athletics. So that would include obviously things like drama, debate, but then also interscholastic sports. So an important thing about the IDEA Act is that it's mostly directed toward students, but there is one provision directed toward employment. And that provision says, quote, shall ensure that each recipient of assistance under this chapter makes positive efforts to employ and advance in employment qualified individuals with disabilities in programs assisted under this chapter. End quote. So there's no case law there regarding this act and athletic department employees, but it is a place where there might be a lawsuit in the future. So the Americans with Disabilities Act, as mentioned, is the one that people are mostly familiar with because that has brought most of the litigation. It's also the most expansive. So with that act, as you can see, there are three titles that we'll talk about. So as you would expect, the Americans with Disabilities Act has some similarity and some crossover to IDEA and also to the Rehabilitation Act. So it was passed in 1990, but unlike the Rehabilitation Act, the Americans with Disabilities Act involves private parties that do not receive federal funds and private places that act as places of public accommodation. So an example there would be something like a movie theater, where it is privately held, like it's owned by the Marcus Group or whoever the movie theater is owned by, but they invite the public in. So it is privately owned, but it is a place of public accommodation. And you'd see the same thing with a restaurant. So again, privately held, but they invite the public in. As opposed to something like a public park, well, that's owned by the government, and they also invite the public in. So that's a key difference there, is that the Americans with Disabilities Act also applies to private entities. But like the Rehabilitation Act, the Americans with Disabilities Act applies or focuses on whether the defendant provided reasonable accommodation on the basis of a known disability. And you can see down at the bottom of the slide, must make reasonable accommodations. And we'll talk more about that in a second. With the ADA, the definition of a disability is similar to what we just talked about with the Rehabilitation Act. So let's talk about each of the different titles. So the first one there, Title I, pertains to employment and discrimination on the basis of employment. So as we talked about with Title VII before, Title I of the Americans with Disabilities Act requires at least 15 employees for a business that involves interstate commerce. So the interstate commerce, I don't think is a stipulation on Title VII, but on Title I it is. On Title I of the ADA it is. So the potential employee must be able to, quote, perform the essential functions of the employment position, end quote, with or without reasonable accommodation. And so reasonable accommodation is one that must not pose undue hardship on the employer, but might include things like facility alteration to allow access, so wheelchair ramps or the automatic doors, those types of things. Job restructuring, so maybe modified work schedules, maybe that the person is allowed more frequent breaks, those kinds of things. That wouldn't pose an undue hardship on the business and would allow somebody with certain types of disabilities to perform that job. Accommodations might also include acquiring or modifying devices to enable them to perform the job, alteration of exams, provision of qualified readers or interpreters, and a number of other things. So a reasonable accommodation is, I guess another way of approaching it is, if somebody requests an accommodation, thinking from an employer standpoint, is that something that is unreasonable? The real question you'd have to ask yourself is the court going to think or decide that this particular request poses an undue burden on our business? And if it doesn't, then that's probably an accommodation that you need to make. So there's a couple of different examples on there. So the first one is Melling versus St. Francis. So St. Francis there is the defendant, Melling is the plaintiff. And so the plaintiff, whose last name is Melling, was a physical education professor who was injured in a car accident. So she filed for medical leave after the accident for the entire academic year between 1993 and 1994. When she tried to file again for a medical leave of absence for the fall of 1994, the school informed her that the leave was only limited to 1 year, and her physician said she could return to work, though only to light duty. So Melling then sought to resume her teaching with modifications and assistance. So, I said she's a physical education professor. So she sought to resume her teaching with modifications and assistance. She also filed for federal disability benefits, indicating that she was totally disabled. When the college learned that she'd filed for disability benefits, they terminated her. So keep in mind, they haven't had any real contact with her to determine the extent of her disabilities and what kind of modifications she might be seeking. So she sued, and the court noted that most of her courses required no physical activity. So think about what I do. Technically, I'm a physical education professor. I don't really have to do much. Or if I did, if I was teaching more of an activity-based course, certainly some of the students involved in the course, or even a teaching assistant or something like that, could demonstrate or do most of the physical stuff that I might have to do. So because of that, because those things are easily performed by a student, the court found that she could have performed her job with that reasonable accommodation. No college representative ever called her to discuss potential accommodations, and the jury ultimately awarded her $225,000 in damage and her reinstatement to the faculty. So a key there is make sure, if you're an employer, that you're in contact with the employee who's been injured or ill or whatever, who's seeking accommodations. Make sure that you have good contact with them and also good records of that contact to verify their disability, but also, of course, to verify any accommodations that they're requesting and any interactions about how reasonable or unreasonable those might be. Another one comes to us in the case of a referee from the Big Ten Conference. So the referee's last name is Clemens, and he sued the Big Ten after he was terminated from his position as a football referee for the conference. So the way that football ref contracts work in the Big Ten is that the refs get one-year contracts and are rated annually on 5 different categories. So the first category the refs are rated on in the Big Ten, or at least were at the time that this lawsuit was filed in the 1990s, the refs are rated on appearance and physical condition, position coverage and movement, consistency of their calls, common sense and judgment, poise, decisiveness and game control, and then the last category is relationship with coaches, players, and others. So between 1990 and 1992, Clemens' ratings plummeted as his weight jumped up to 270 pounds, at which time he started to receive notices about his weight. And effectively, the notices said that because of his weight, he wasn't able to perform the job satisfactorily. He wasn't able to move as well, to keep himself in a good position to make calls. And so because of that lack of ability to move around and stay with the plays, he wasn't able to make good and consistent calls. So the following year, he again got a poor rating, and his weight went up to 280 pounds, and he was placed on probation. The year after that, so 3 years in after he received notice, he reported for work at 285, and his contract was canceled. So the question is, do you think he won suing under the Americans with Disabilities Act? Basically, he's claiming that the Big Ten is discriminating against him based on the disability, which in this case is obesity. And before you have too long to think about it, I'll answer it for you, and the answer is no. Except in rare conditions, obesity is not considered a disabling impairment. The court found that he was not disabled, as his ability to perform other jobs was not impacted, and the ADA was not meant to cover exclusion from a single position of employment. So he didn't demonstrate that his inability to keep up with players did not impact his performance. He couldn't keep himself in a position to make the calls, and so remember that an important thing here is, are they otherwise qualified? And so in this case, because of his weight, which one of the things about that is rather than some sort of traumatic or genetic condition or something else that might have led to other types of disabilities, part of the reason that courts oftentimes don't consider obesity a disability is because there is a perception that it is based on behavior and personal choices, right? And certainly that is part of it, and that's not the entire story, but certainly that is part of it. So obesity is certainly regarded differently than other conditions which are more commonly regarded as disabilities. As far as public entities go, so that's Title II. So that covers any organ of the state or local government. So that includes obviously federal court buildings, that includes parks, that includes any sort of museums that are run by the government, anything run by the government buildings, those kinds of things. And so what Title II says in terms of the relevant language is, quote, no qualified individual with a disability shall, by reason of such disability, be excluded from participation in or denied the benefit of services, programs, or activities of a public entity, or be subjected to discrimination by any such entity, end quote. And so key case here comes from 2004 from the Tennessee State Court building. And so what happened here is that the case was brought by individuals in wheelchairs who were not afforded accommodations like elevators to reach the upper floors of the Tennessee State Court buildings. And so because there's no elevators, what they did was they would have individuals who would actually carry people upstairs because there's no elevator. And so the problem, the bigger problem, other than that that's fairly demeaning, is that if there was nobody available to carry the people upstairs for their court appointments, then they had to literally crawl upstairs in some cases. And so, as horrifying as that is, and again, the late date on that surprises me, is from 2004. So, within the last couple decades when that was brought to court. So, of course, then Tennessee had to modify their state court buildings because the individuals who are in that building, by and large, are there because they legally have to be. Certainly, there are some observers who are there, but for the most part, you're there as part of some sort of a court case. You're legally bound to be there, and so, particularly in that case, the state is obligated to provide access to those facilities. Title III is where we get to places of public accommodation. So again, broadly speaking, a place of public accommodation is any place where you invite people into. So, that can be stadiums, that can be theaters, parks, because that's a public accommodation even though it's publicly held. Where else? Swimming pools, gyms would be places of public accommodation, libraries. So any place that you're going to invite the public into, that's a place of public accommodation. So obviously that's pretty broad. And so what Title III says that covers public accommodations is, quote, no individual shall be discriminated against on the basis of disability, of the full and equal enjoyment of goods, services, facilities, privileges, advantages, or accommodations of any place of public accommodation by any person who owns, leases, or operates a place of public accommodation, end quote. So, to give you a more specific definition that actually comes from the wording of the law, a place of public accommodation includes, quote, a private entity which affects commerce through operation of a concert hall, stadium, or other place of exhibition or entertainment, a nursery, elementary, or secondary school, or other place of education, or a gymnasium, or other place of recreation, end quote. So again, broadly speaking, any place that you invite people into. So the owners of those facilities must make reasonable accommodations unless they would fundamentally alter the nature of goods, services, facilities, privileges, advantages, or accommodations. So similar to what we talked about with the idea of the undue burden. So you have to make reasonable accommodations to allow access to the facility unless you can show somehow that doing so causes some sort of an undue burden. You can also, if you're the owner of the facility, exclude disabled individuals who would pose a significant risk to the health or safety of other individuals. So if based on their disability, they might harm others or they might cause others to, let's say, not be able to evacuate the building in a timely fashion, something to that effect, then that's something where you could exclude certain types of disabled individuals. So a key case here comes from 2001. It's the case of the PGA Tour versus Casey Martin. So Casey Martin is the guy pictured there in the golf cart in the lower right of the slide, and he is currently the head golf coach at Oregon. So back in the late 90s and early 2000s, Casey Martin was a pro golfer, and he had a circulatory problem that would be made worse if he was forced to walk the golf course. And so what he wanted to do was to use a cart during the PGA Tour pursuant to the ADA. So he said there was a reasonable accommodation that would allow him to participate in the PGA Tour if he were allowed to use a cart, so that his circulatory condition would not be made worse. The PGA claimed that walking was part of the game, and so because of that, they banned cart use. But it's important to note that at the time, both the NCAA and the PGA Senior Tour both allowed use of carts for individuals with disabilities. So it's only the big PGA Tour that was taking a stand here and saying that carts would not be allowed. So a key part of this is that with the cart, Martin was able to participate, and without it, he couldn't. So the course is a place of public accommodation because the public was invited in, and anyone can try out for the PGA Tour via something called the Q School. So reasonable accommodations are necessary to avoid discrimination on the basis of ability unless modifications would fundamentally alter the service. And so that's one of the key questions here is, does that fundamentally alter his ability to participate in the PGA Tour? The initial ruling at the district court level said that walking was incidental to the game, so it's just something that you kind of also did, not an inherent part of it. So the district court said that the key parts of the game were actually, obviously, driving, getting out of traps, putting, etc., and that walking was just something that you had to do to get from point A to point B, and so it didn't really affect the game. What really affected the game were your ability to make shots. So the Supreme Court agreed and said shot making was integral, but walking was not an indispensable part of the tour, and that, walking was not an indispensable part of the tour, and that fatigue that might be induced by walking the course was pretty minimal, and so providing the cart on the part of the PGA Tour would not provide an unfair advantage to Martin. So the PGA Tour, or the court also said that the PGA Tour did not sufficiently consider Martin's disabilities on an individual basis, which the ADA requires. So the ADA, one of the things that they want you to do is to look at each individual's case on a case-by-case basis. And so not just make blanket, no, you can't use carts, or yes, everyone can, but to make particular accommodations based on the extent of individual disabilities. So you can see there, in order for a plaintiff to be successful in a claim, that's what they have to prove, that they have a disability, that they're qualified for the job. And so in the case of Martin, he was qualified because he got through the qualifying rounds with the use of the cart, that the employer knew of the disability before the decision was made, and the adverse action was because of the disability. All right, so that's disabilities. And so, moving on, there we go. Let's talk about age discrimination, which is something that hits entirely too close to home. So, just before we get into it, question for you is, at what age do you think age discrimination becomes a factor? And as you think about that, so, for example, if I wanted to file suit saying that I had been discriminated against on the basis of my age, how old would I have to be? And the answer to that question is 40. So that's why that one's hitting a little too close to home. So you can see there that the employer can't discriminate in hiring, firing, compensation, terms or privileges of employment based on age. And again, that protection starts at the age of 40. So things that the plaintiff might allege, so you've got direct evidence of discrimination. That's pretty rare. So the key here is that with any of the age discrimination suits, the plaintiff has to show that age is the determining factor that they were not hired, fired, or not promoted. And so in terms of direct evidence of discrimination, the plaintiff is going to have to show that the defendant effectively said, we're not hiring you for this because you're too old. And so that direct evidence of discrimination is pretty tough to find, because usually that's more inferred. So for example, having been on hiring committees at other places, not at Whitewater, but at other places, one of the things I've seen people do is to look at the length of a resume and basically say, okay, well, we can infer that this person is probably close to the end of their career, so they probably won't be here for very long, so we'll maybe put them closer to the back of the pile. So, but of course, the damaged party in that case would not be aware that that sort of a thing happens, but it does. So in terms of direct evidence and something related to, or age discrimination related to sports, there's not a ton of cases that I could find. One of the more interesting ones, and one of the ones that provides direct evidence of discrimination, comes from the University of Notre Dame, and the guy you can see pictured on the right there, his name is Joe Moore. So Joe Moore was an offensive line coach at Notre Dame, and then Bob Davie, at the time, was promoted from defensive coordinator to head coach. So a little bit of the backstory here is that in 1996, Lou Holtz retired as the head football coach at Notre Dame. So he was the last one to win a national championship there in 1988. And he was succeeded by his defensive coordinator, Bob Davie, who'd been hired to the position from the University of Pittsburgh based on the recommendation from Joe Moore. So the reason that Davie becomes the defensive coordinator is because Moore had worked with him at Pittsburgh. Shortly after becoming the head coach, Davie fires Moore, and allegedly he told him, quote, "You're too old, Joe," end quote. And further, Davie told Moore that he wouldn't be able to coach another 5 years. And on top of that, in an interview with Notre Dame Magazine, Davey said that Moore could only coach 1 or 2 more years. So we have pretty effectively have direct evidence of discrimination that was the determining factor in why he was released, was because he was close to the end of his career, and so Davey wasn't confident that Moore would be able to coach much longer. The same article in Notre Dame Magazine, but it's not a direct quote from Davey, but the same article said, quote, "At 64, Moore was no longer capable of putting in the hours of his coaching cohorts, and he had long ago abandoned an all-for-one, one-for-all approach," end quote. So, as you can imagine, Moore claimed that those comments damaged his reputation and made him unemployable as a college coach, because effectively they've pointed out his age, but further they've said that because of his age, or at least implied that because of his age, he's not able to put in, the 100-hour weeks that oftentimes college coaches do. So the court ultimately found for Moore, ordering compensatory damages of $75,000 and, here's why you'd want to go to law school, legal fees of $395,000. So after all of that, several years worth of lawsuit, in order to get a victory in court, Moore only gets $75,000 in damages while his lawyers get $395,000. Some other interesting things about this, though, not only was Moore the reason that Davey was there in the first place, but Moore was actually a really, really good coach. So he'd been the offensive line coach from 1988 when they won their national championship at Notre Dame until 1996. And Sports Illustrated during that time called him the best offensive line coach in football. And Notre Dame, again, trying to justify it to say that it's a for-cause firing and not something related to his age, Notre Dame said that Moore was fired because he didn't measure up to the university standards and that he had intimidated, abused, and made offensive remarks to players. But of course, based on all the other things that were said about him, that wasn't the reason that he was fired, and he'd been praised for his job previously. So ultimately there, again, Moore is successful. So that's direct evidence of discrimination. Moore was able to show that he was fired in that case based on his age, or not retained at the very least based on his age. Disparate impact discrimination is like what we talked about as far as race. So disparate impact is there's some sort of a rule that keeps people older than 40 from doing that job or being eligible for that job. So that would be the example I gave earlier of the rule that you had to bench press 300 pounds or something to that effect in order to perform the job. Now again, the thing that the business would use or employer would use as a defense is that it's some sort of a bona fide occupational qualification. You have to have this level of strength in order to perform this job. And an offshoot of that is related to public safety, which is what I talked about with the firefighting example, that you have to be able to perform certain physical tasks in order to function as a firefighter. And so, yes, that may discriminate against people above the age of 40 or 50 or wherever, but that's acceptable because that is required in order to ensure public safety. So that then falls under business necessity. There's a reason that you have to have that requirement in place. But again, you have to show a really obvious connection that truly you have to be able to perform this physical task in order to perform the job. If the two are just sort of peripherally related, well, then that's not something that's going to be allowed to continue. You're not going to be able to keep that rule. All right. So then next one, sexual harassment. So sexual harassment is briefly unwanted treatment based on someone's gender. So sexual harassment consists of conduct that's sexual in nature and can occur with any combination of gender. So it doesn't necessarily have to be male-female. It can be male-male, female-female, etc. A key stipulation, and there are several, but one of them is that sort of treatment is not consensual between both parties, because of course you can date at work or date coworkers. It may be frowned upon, but you can date coworkers provided that the advances are consensual on both sides, that the coworker is also interested in you. So as you can see there from my boldface type, unwelcome is the key word. So any conduct which the employee did not solicit and which the employee regards as conduct that is undesirable or offensive is an unwelcome behavior. So something they didn't want and something that they regard as undesirable or offensive. And those types of behaviors are pretty broad. So you can see the bottom bullet there under consists of is that it can arise from verbal or physical conduct. And so the behaviors that are included under unwelcome advances are pretty broad. So that can include things from staring to gestures, flashing, dirty jokes, whistling, obscene calls, starting rumors, requests for dates, asking highly personal questions, love letters, cards, or notes, violating personal space, pinching, rubbing, or patting, bra snapping, blocking or tackling, using a position to request dates or sexual favors, and then it goes downhill from there into various forms of assault. So there's a variety of things that can be included under that umbrella of unwelcome advances. But a key point here is that the employee has to demonstrate a causal link between gender and their conduct in order to evoke that Title VII protection. So on the second of the discussion boards for this week about the workplace where they're manufacturing mascots, that's one of the key things I want you to consider is, did the treatment of the employee arise because of her gender, or is it just kind of a generally terrible workplace? So try to think that through as you're reading through that particular scenario. So, if those unwelcome advances create a hostile or abusive work environment, then that is where the real problem comes in. So obviously we have to identify, or we have to define what a hostile or abusive work environment is, and that is one in which someone is so affected by the sexual conduct and finds it so offensive or intimidating that it negatively affects their job performance. So the environment has become so filled with intimidation, ridicule, and insult that it adversely affects the harassed person's job performance. So that could be, maybe the person who's doing the harassing is somebody that you have to interact with for budget reasons, or they sit by the copy room or something like that. And so because of their physical position, and you just don't want to deal with them, that you go around them, or maybe you start calling in sick to work more often, and it becomes more difficult to do your job, which then negatively impacts your own performance evaluations, those kinds of things. That would be a hostile or abusive work environment. If it changes the way that the harassed person works, then that's a hostile or abusive work environment. So having said that, the court's going to consider what's referred to as the totality of circumstances. So that's going to include both the nature of the conduct and the context in which that conduct occurred, as well as the severity and pervasiveness of that conduct. Whether that conduct is physically threatening or humiliating, whether it was unwelcome, and whether it was whether it unreasonably interfered with the employee's work performance. So in terms of totality of circumstances, the two really important things there are severity and pervasiveness. So was it an off-color joke, something to the effect of women belong in the kitchen, that was ill-advised but only said one time? Well, that's not great, and it shouldn't have happened. But in terms of the severity, it's not physical. So something that was said is typically regarded as less severe than something that's physical. And then the pervasiveness, if it just happened one time, well, then that's not really a pervasive feature of the work environment. Now, that said, if those types of jokes happen every day, multiple times a day, well, that's not very severe, but it is pervasive. And so it's enough that the harassed person would start to feel unwelcome in that work environment. So then that would be a hostile environment, something that a reasonable person would perceive there. So the reasonable person standard here is, would a reasonable person, based on all of those circumstances, perceive this to be a hostile work environment? So reasonable person standard continues to appear, as you can tell. Quid pro quo has made the news a lot lately from a political standpoint, but as far as quid pro quo goes, it means this for that. So effectively, it is something in exchange for something else. So as it pertains to sexual harassment, the really common iteration is sexual favors demanded in return for things like raises, promotions, better office, those kinds of things. From a sporting standpoint, it might be something like a female reporter's access to athlete interviews being granted contingent upon her accepting a date request, or something like that. So as far as actual examples, so the woman there pictured on the right, her name is Annika Brown Sanders, and she worked for the New York Knicks in the early 2000s. So in 2006, she was the vice president for marketing and business operation for the Knicks. She was fired from that position in 2007. She claimed she was fired because she complained that then Knicks president Isaiah Thomas harassed her, and that the firing was in retaliation. An assistant coach testified that Thomas, the president, called Sanders a, quote, bitch, and a hoe, end quote. Thomas was allegedly really touchy-feely with Sanders, tried to kiss her on more than one occasion, and she recoiled, but he defended himself, and other witnesses testified that Thomas is just generally that way. He's very touchy-feely with everybody. Sanders claimed that Thomas told her that he loved her. So an important facet of this is that Sanders was awarded a $76,000 bonus just a few months before her firing. So that bonus was based on performance. So obviously you're not going to give somebody a gigantic bonus like that if they're not doing their job well. Now, after she was fired, the Knicks claimed that she was incompetent at keeping a budget, and so she was fired for that. And a former Knicks executive testified that she hadn't said anything about Thomas's actions until shortly after she approached him in tears, saying she was overwhelmed by her position and was considering leaving. He also said the team was considering removing her in the previous year, in 2005, for an inability to budget. But again, all of that said, they still gave her a bonus, a pretty significant bonus of $76,000 in 2006, based on her performance. So because of that, because everything pointed to that she was performing her job well, and she was fired probably in retaliation, a jury awarded her $11.6 million for her hostile work environment claim. So one of the key questions here is, as an employer or as a future sport manager, how might we deal with this? And one of the big aspects of dealing with this is making sure that there's a good reporting structure in place, and making sure you follow up on those stories that you might hear, or any sort of reporting you might hear about inappropriate behavior. So also related to gender, the Equal Pay Act of 1963. So that's related to an employer discriminating in pay on the basis of sex. Essentially, you've got a man and a woman who have the same jobs. They should be paid the same amount because they perform the same work. And so that is, paying them differently on the basis of sex is prohibited by law, specifically prohibited by the Equal Pay Act of 1963. So if a woman is going to, and it doesn't have to be a woman, but it's almost always women, because they're usually the ones being discriminated against, if a woman is going to claim that she is being paid less on the basis of her sex, so she's going to have to show a few things, and you can see those listed for you there. So she's going to have to establish that the work is substantially equal, effectively that they perform the same job, that requires the same level of skill, same effort, and same responsibility, and is also performed under similar conditions. So there are some exceptions to that. So men and women performing the same job don't always have to be paid the exact same amount if there are differences, for example, in qualifications, in their seniority. The employer just has to show that the difference or the pay discrepancy is based on some factor other than sex. So there's a case study we often do, but we won't have time to get to this year, where the women's basketball coach at USC is trying to get paid the same as the men's basketball coach in the early 1990s, and so she files a lawsuit against USC claiming that she makes significantly less on the basis of her sex. But she ultimately loses the case, and the reasons that she loses the case have everything to do with who the male coach was. At the time, he had coached the Olympic basketball team. He'd written a couple books on coaching. He appeared at coaching conferences all across the country. And so those are a bunch of things that she didn't do. He also had been a head coach for a longer period of time than she had. And so the university was able to point to all of those other non-discriminatory factors to show that there was a reason for the pay discrepancy between the two. It wasn't just that she was the women's coach, but in fact that there were other differences in their qualifications, and so that was why she was paid differently than her male counterpart. So in that case, USC was successful. The map you can see there on the lower right is what women earn relative to men. So the darker states, women earn almost as much as men do, but still not quite. So you can see there, if it's almost the navy blue, women earn 90% as much as men do, but still not 100%. And then the lighter the colors get, the bigger the pay discrepancy. So in places like Louisiana, Utah, Idaho, etc., women can earn as little as 68% of what a man does, or 68 cents on the dollar for a man performing the same job. So Wisconsin's kind of in the middle, at least based on 2017 data, but there is quite a bit of evidence showing that women are still paid less for the same jobs in a variety of fields, so obviously not just in a sporting context. There we go. All right, so other employment laws. So the Occupational Safe and Healthy Health Act is one that might come up if you've got, if you're dealing with pool chemicals. So basically, workplace dangers that you knew about or should have known about that you would need to protect your employees from. So OSHA requires employers to meet certain specific federally mandated safety standards, and imposes a general duty on employers to keep their workplaces safe. So your employer, or if you are the employer, you have a duty to keep your workplace physically safe, so to prevent reasonably foreseeable hazards and to protect against them. So possible health hazards in a work environment include things like sudden cardiac arrest. So if you think about coaches, sports supervisors, heat-related illness, carpal tunnel syndrome, heavy equipment-related injury. So think about field workers who might get injured with the mowers or various different chemicals or equipment that they might have to use while treating the fields. Blunt trauma. So think about like batting coaches. Again, chemicals. So aquatic staff, athletic training staff, and also things like bloodborne pathogens. So athletic training staff would deal with that as well. So regarding bloodborne pathogens, so exposure to things like hepatitis, employers must identify job classifications that might be exposed to bloodborne pathogens, and once they've done that, they have to provide protective equipment, which includes things like gloves and masks, and have to offer hepatitis B vaccines to all employees who have occupational exposure. So importantly, OSHA applies to employers with 11 or more employees, and the employers have to keep track of work-related injuries or disease, and must report to the Department of Labor work-related accidents resulting in the death or 5 or more employees hospitalized. So if one of your employees dies, obviously you have to report that, or if there are 5 or more employees hospitalized, you have to report that. And it seems like that number would be lower than 5. So one of the few cases I can think of related to sports comes from Notre Dame again. So Notre Dame's a prominent feature in this chapter. And it comes from the death of one of the videographers who was an undergraduate student at the University of Notre Dame in 2010. So in October of 2010, one of Notre Dame's videographers, as I mentioned, an undergrad by the name of Declan Sullivan, he took his spot on a scissor lift to film practice, and you can see the scissor lift pictured there for you in the lower right. The lift went up 50 feet in the air, and there were strong winds that day. There was a big front blowing in. And so it was known that there was this big front blowing in, and it was predicted or projected that there would be really significant winds that accompanied that front. And in fact, the gusts exceeded more than 50 miles an hour. But nonetheless, Notre Dame, and specifically Notre Dame's head coach, made the decision to film practice from those scissor lifts anyway. So while working 50 feet in the air, Sullivan tweeted, quote, "I guess I've lived long enough," end quote. And then a second tweet said, quote, "This is terrifying," end quote. Shortly before, the lift blew over onto a street behind the practice field and killed him. Now that said, most of these kinds of lifts have warnings not to use them when wind speeds exceed 25 miles an hour. And some universities, like Texas Tech, have written policies dictating the use of the lifts. And others have replaced them with permanent towers, so think of something like a deer stand, and required safety harnesses be attached to those towers. Notre Dame wasn't the first time something like this had happened. Students at James Madison University suffered serious back injuries under similar circumstances in the mid-90s. And in 2000 at Colorado State, a videographer suffered broken ribs, punctured lungs, and a lacerated liver from falling out of one of these kinds of scissor lifts. So the interesting part about this is that, and where OSHA comes in, is that the family declined to sue Notre Dame. They were, as far as I can tell, a very, very Catholic family. And so they had no interest in suing the university. They didn't feel like it was any sort of intentional act on the part of the university. And they essentially said that they didn't feel like suing the school and getting money from the school would accomplish anything. And so they declined to sue. OSHA, though, fined the university $42,000 for failure to prevent this foreseeable workplace accident. And if you have time, and at this point you probably do, there's an ESPN, I think it's a 30 for 30, or it might be one of the E60s, I'm not sure which one it is, but it's on this incident, and so they give a bunch of background on it. They've got some really good footage of the weather forecast and that kind of stuff, but the kind of cool part about the story, or the sort of silver lining to this story. So as mentioned, the family declines to sue, but they ultimately get a bunch of donations to them following Declan's death. And so what they do is they said, we felt really guilty that we might profit off of his death, essentially. And so they then take that money and put it into an account and then use it to fund schooling to help students get into Notre Dame and to help pay for their schooling once they get into the university. So turning a tragedy into something really, really positive. So it's a good show. Like I said, if you get bored, it's worth watching. So that's OSHA. So you have to protect your employees against reasonably foreseeable accidents or threats to their physical safety. Other things, so the Fair Labor Standards Act, as you can see there, that applies to child labor. So it has different rules as far as when they can work. So for example, kids aren't supposed to work before 7 a.m. or after 7 p.m. during the school year, and not after 9 p.m. in the summer. Not supposed to work more than 3 hours on a school day or more than 8 hours on a non-school day, more than 18 hours during a school week, or more than 40 hours during a non-school week. And it also sets minimum ages for different kinds of jobs. So another one on there, the Family Medical Leave Act, or FMLA, gives you up to 12 weeks of leave that you can return to your job, but you don't have to be paid for that. So if it's something like, where this came up personally, was when we had our son, my wife had basically banked a bunch of her vacation time so that she was able to take those 12 weeks off and still retain her job under FMLA, but so that she could be paid, she made sure to bank her vacation time. So just something to be aware of is they have to hang on to your job for you, but at the same time, it doesn't have to be paid leave. So where you also see that is when, not just in childbirth, that's a really common use of it, but another one is if you get, you got a family member that's really sick and you need to take care of them. So that's where that one comes up as well. The last one on this slide, the Consolidated Omnibus Budget Reconciliation Act, or COBRA for short, says that you have access to your health care after you leave your employer. Now that said, if you have health care through your employer, the way that works is your employer typically pays a pretty significant chunk of that, maybe half or more of that, and so what you pay is not the full cost. And so once you've left the job, you still have access to the insurance, but then you have to pay the employer portion as well, which gets pretty expensive. I think, so when we first moved up here, it took 90 days for our insurance to start once we took our new jobs up here, and so we continued my wife's insurance from Texas for our first 3 months up here. And so having to pay the full cost of our insurance, I think was like $1,400 a month. It was a lot. So that's kind of the downside. The good side is, you have insurance, but the downside is it is pretty expensive. And then we've got the Health Insurance Portability and Accountability Act. The short thing to know about it is that it protects your medical records. So it says that you can't be excluded from insurance coverage on the basis of a pre-existing condition for which medical care, advice, or treatment was provided within 6 months before coverage would begin, and that people that have your health information must do what is reasonably necessary to ensure that health information is not available to those without the permission to have it. So if you want to transfer your medical records, typically there's some sort of a sign-off form that you have to do so that your doctor has proof that when they gave up your medical information, that they had your permission to do that. From the standpoint of professional sports, a player's job outlook may be adversely affected by their health information getting out. But having said that, so if the employer, professional football teams, etc., know all about your injury history, well, then that obviously is going to affect your ability to make a particular club or their willingness to draft you, those kinds of things. So it would be helpful for players to be able to hide that information. But that said, Health and Human Services has interpreted the rules to say, quote, nothing prevents an employer from making an employee's agreement to disclose health records a condition of employment, end quote. So the NFL can require prospective draftees to release their health information to the league and to the clubs as a condition of their employment in the NFL so that they can't hire that. But again, can't hide that, I meant to say. So obviously it would be helpful for the players if they could, but the Health and Human Services interpretation is that the employer can simply make it a requirement in order to be employed. All right. Well, thank you for battling through all of those slides with me. So that is effectively a week's worth of material we got through there. So we're through employment law. Make sure you do the 2 discussion boards for this week, and then next week we move on to constitutional law.